the Law and Crime Network. My name is Bob Bianchi. I'll be taking it from 3 to 5. We have breaking news here at the Law and Crime Network. We covered gavel to gavel, as we do with all of our cases, the fascinating death penalty case of Timothy Jones here. This case right now, they've come back with a verdict in the case with regard to guilt in the penalty phase. They now have a verdict in that penalty phase. We are waiting to go back to court to find out what that verdict is. As you know, in the Law and Crime Network, we're doing multiple trials of high-level significance, gavel to gavel. We're not just playing clips over and over again. We're watching these cases live, and we just watched a live result of the Timothy Jones case, and it was hotly disputed as to whether or not he would get the death penalty or not. There were people that were going on both sides of this, even at the Law and Crime Network. I have the pleasure of having, at the last minute, come into the studio Aaron Keller, one of our pros here at the Law and Crime Network. Welcome, Aaron.
Good to see you, Bob. Okay, well, you know, I had to run in and react to this along with you because, of course, this is huge. This is a huge verdict.
Yeah, so, you know, when we were talking back there before, I don't know if you were part of those discussions, we were talking about how quickly the jury had come back. And some were suggesting that, you know, before a jury usually imposes death, they take a lot of time to go through the evidence. But this jury came back pretty quick. I think it's a decisive verdict for the prosecution. They didn't have any hesitation in their mind. Death was the only appropriate way to equalize the carnage, the mere carnage, as I call it, of this case. What are your thoughts?
I agree. Look, you know the old rule, Bob, and of course, sometimes this rule is violated, but usually when there's a quick verdict, it's something that's in favor of the state. In other words, that the jury believed lock, stock, and barrel what the state was arguing. In this case, when I heard there was a verdict, I just said, oh no, this is probably going to be a death sentence. And that's exactly what happened here.
Yeah, you know, Aaron, yesterday there was some interesting testimony presented by the defense, and I want to get into this dynamic, especially with the mom, because nobody suffered greater than her. She lost all 5 of her babies. This was her ex-husband. You could just see, I used the only word I could think of is anguish, as she was testifying both in the guilt phase and the penalty phase. And at one point she said, I'd like to rip his face off. That's a quote.
Yes.
But she said, I don't want him to get the death penalty. And then she gave a little caveat that I thought was really bad for the defense, because I don't want to be the one responsible for his death. And I think, in my mind, the jury is going to go back and say, darling, don't worry about it. You're not going to be responsible. Hold us accountable.
The jury felt as though it had to step in and assume the role of the arbiter of justice in this case. That's something that the jury probably took very seriously here. But look, I think that with a verdict this fast on a penalty phase of a death penalty case, that suggests to me that this jury had been mulling over this result. They probably weren't talking about it ahead of time because the judge tells them not to, but they were thinking as they heard this evidence roll out, they knew that they were sitting on a case that could go to the death penalty. And I suspect that most of them, if not all of them, had made their mind up back when they convicted the guy that this would be the next step in their minds.
Yeah, Aaron, you know, in the guilt phase, there was the insanity defense that was brought out, and the jurors had a number of different options, one of which is that he was mentally ill, and they basically discounted, in my mind, the psychiatric testimony, which to me was very bad for him, because if that's so, it may flush its way into the penalty phase, and they're going to say there's not a psychiatric illness that caused this. These were his choices, like the prosecutor said. Were you surprised that the jury didn't buy any of that psychiatric defense at all? Because there is a history here.
You know, that's going to be the huge issue on appeal here. And I see this being one of those cases, more so than others, that's going to be stuck in the appeals process for quite some time, because you have issues in this country with attempting to execute someone with mental health issues. Mm-hmm. You know that. The court says, you know, we just don't do that. So the appeals courts, that is. So here you have someone who does have that history. And, you know, does the appeals court look and just say, well, the jury didn't buy any of it? But then, okay, what about the evidence that it runs in the family? What about some of the other pieces of evidence out there? This is going to be a tough one to try to chew on to make this stick.
Yeah, I was going to ask you that very thing. I mean, this is what we do as lawyers, right? We've been waiting for this monumental verdict to come in, and the minute that it comes in, we barely take a breath, and we're talking about appeals already, but it's something that we would think of. I think the case went in very clean. I think the lawyers for the defense were very, very capable. They had a very difficult case to deal with. They were handed really bad cards, but to your point, I think that the appellate courts are going to look at this from the way this record was developed in my mind, as I saw it, and say he was given an ample defense, and that jury's job is to assess whether or not there are aggravating and mitigating factors, and there was nothing that they did that was inappropriate.
You know, I could see that because, look, we had that defense, and then the question is it an excuse? It's one thing to raise mental health issues, and maybe even some members of the jury turned around and said, well, we agree that there may be some mental health issues there, but they didn't reach that middle verdict, that guilty but mentally ill. They didn't reach that. So if they believed there were some issues there, then they were just that. They were some issues. They weren't the big issue. And here, when you have a defendant who's making this morbid shopping list of what he needed to do to effectuate and cover up the deaths of the 5 kids, and then driving around across state lines with the kids in the back of this Cadillac. They're not in a trunk area, they're in the cargo. So you're dealing with a smell, you're dealing with deliberate actions here, and I think that when the jury looked at that, they turned around and said, okay, this does meet the legal qualification for a volitional act. In other words, something that the defendant chose to specifically do. This was not mental illness, because if it was mental illness, then likely the episode would have lasted a much longer period of time. No. There was a list. There was a plan. He was searching for legal terms online. Okay. He was looking for places he could run that don't have extradition treaties with the United States. Right. Remember all this evidence? I think that that's the kind of evidence that the jury, if the jury was searching for something, how do we come down on this case? This is a big case. We're on a big case. How do we come down on it? I think that those were probably the pieces of evidence that the jury looked at and said, that's what we needed. That's why we made this decision.
Yeah, I think that's a great analysis, Aaron. And, I've handled NGI cases where the person kills a child. In fact, I'm thinking one in particular. Cops were crying. It was a very gut-wrenching thing. A woman had just been released from a psychiatric facility. She wasn't given her meds. She decompensated and was found on the ground talking to God. Like, how come you're not resurrecting the child? How come you're not resurrecting the child? Those are cases where clearly the mental illness was driving the actions, and she wasn't able to appreciate even the difference between right or wrong. And I always wondered for that poor lady, when she gets medicated and gets back into a sane place, she's got to live with the rest of her life that she killed 2 of her kids. But to your point, that's not what was going on with regard to this. And the psychiatrists always look at their actions both before, during, and immediately after as to whether or not the psychiatric illness was driving it. And to your point, he was doing a lot of planning and plotting to get himself out of trouble. That certainly isn't a psychiatric defense.
That's what the jury looked at here and said, no, wait a minute. If you had done this, okay, and then came to at some point immediately thereafter or within a reasonable time, said, oh my gosh, I need to report this. He reports it, and then you've got a different kind of defense. But no. When you're making lists, when you're looking for places to flee, countries that don't have extradition treaties with the U.S., when you're doing that, then you're covering up something that you knew was wrong. Yeah. And I think that's the piece of evidence that the jury needed.
Aaron Keller, I think that when you review the appellate decision that will eventually come down with respect to this, as it should, I mean, you're going to take somebody's life, you should go through those processes. I'm going to bet that they're going to tick off the very things that you just did here right now as to the reasons why the jury's verdict made sense based upon the evidence, and that they were not overcome by this passion or prejudice that, oh, he has a psychiatric illness, therefore we can't impose the death penalty. And I can't see an appellate court with 5 babies being killed reversing this kind of case. I don't see that kind of error here.
That's for them to decide. I don't know if I'd want to sit in their shoes to make that decision, nor would I want to really sit in the shoes of the jury, because, again, at the end of the day, this is a bad case. It's a sad case. You saw the father weeping after the sentence was read. Again, this family's going to have another person taken away. As the defense oftentimes says, sometimes mercy is a choice, even for the worst of individuals. I think as humans, we have to look at that and consider that. But as a matter of law, I think the appeals court has something to hang its hat on if the appeals court wants to make this stick.
Aaron, can you talk to our audience a little bit about what was going on there? You remember the clerk was reading the verdict. You could tell she was very nervous. It's a very intense place when you're in that courtroom for the lawyers that are sitting there waiting for the verdict and for the judge as well as the clerk. But when she was reading the aggravating factors that the jurors had found, explain to them what's going on there about the aggravating and mitigating factors as it relates to a death penalty case.
So as it goes down with death penalty, as you well know, Bob, you have to argue aggravators and mitigators. Obviously, the prosecution wants to have as many aggravators as possible, more than one victim, et cetera, et cetera. These are things that make this defendant look extra bad. In other words, that's an aggravating circumstance. The defense wants to try to mitigate, and oftentimes the aggravators are set forth in statute, but the mitigators can be anything that ever went wrong in this defendant's life. It can be that he was picked on when he was in elementary school. It can be that he was, that he had something else that was wrong with him, mental health issues, marital issues, that he struggled with finances. Anything can be a mitigator in most states. And the jury has to then sort of tally up how many aggravators do we have, how many mitigators do we have, and then which side outweighs the other, and then they arrive at a verdict.
Well, it is an uneven playing field, as you put. The aggravating factors are very specific, and the prosecution is limited to that. And as you suggest, in most states, the mitigating factors can be almost anything not to give death. And the prosecution has to prove those aggravating factors beyond a reasonable doubt with regard to all 12 jurors. And then each one of them individually has to make the determination that beyond a reasonable doubt, the death penalty is the appropriate sentence. So there's a lot of roadblocks legally that make the playing field uneven. And it should be that way when you're talking about taking somebody's life. But Aaron, this case was fascinating to me. I cannot help. I got to look at the sentencing one more time. And if you don't mind bearing with me,
let's watch it.
Let's take a quick look. The nervousness and stuff, or are you just kind of pretty much just calling it down the middle and citing the facts and just moving on?
I think it might be the same process that you go through, Bob. You find your own way as a human to grapple with what you're dealing with. You find your own way to make meaning based on whatever turmoil you're thrust into as a journalist. But the mental process you have to go through is you have to then say, okay, that's for me to worry about when I'm home, when I'm among friends, family, clergy, whatever it may be. And then my job here is to report what happened so that other people can make their mind up as best they can. That I need to explain what's happening factually, based on the process, of course, the law, the legal process, and then what else is going on around me that I can observe with my senses. News is information that you glean from the environment and then you pass on to other people. And that's ultimately the job. Aaron,
I'm going to put you on the spot. If you had to give a sentence or a byline, I'm not sure what they call it, about the result of this case, in your mind, what would Aaron Keller be writing in a one sentence, very couple of words about what this case represented?
Boy, that's tough to come up with. I have to think about those lines, Bob. I would have to say, whenever something this serious happens, it crushes the souls of multiple people, and I think that we watched that play out. We heard it in the voice of the clerk. We watched it in the reaction from the family of the defendant. We certainly watched it from the mother of the victims. There aren't winners, and I know people say that from time to time, and it's a phrase that becomes overused. But in something like this, it's a tragedy for all who dealt with it. And I don't think that there's any way to ever sit and watch something like this happen and be happy about it. No one should be happy that they decided to put someone to death.
Yeah.
Legally, is it the just thing to do? Well, that's for the jury to decide. It's not for me, it's not for you. That's for the jury to decide. They had to decide that. But I don't think anybody should be happy about it.
You know, Aaron, it's funny. I used to say that, actually got critiqued a lot when I was a young prosecutor, that I never was happy. I was professionally satisfied that it was a guilty verdict, but I wasn't elated about the idea that the event even happened and that I was part of a process where somebody's going to have to pay for it. I mean, I was kind of like professionally satisfied, like I said, but I never took glee in it, and I've seen some people do that. And when I became the head prosecutor, I always used to tell my staff, you don't judge people, you judge conduct. Because
exactly.
when you start judging people...
And look, that's why the judge that I clerked for, when he had to do a sentencing hearing, he would try to level with defendants. He didn't try to sit up high on the bench and point the finger down at them. He would say, you know, look, this is the end of this process, but your life continues. You need to promise me, man to man or woman to man, the judge was a man, that you're going to go and you're going to take part in classes. You're going to try to better yourself so I don't have to see you here again. Or if I do see you again, it's going to be at the restaurant. It's going to be someplace else. This assuming that it was a lower level crime, obviously, where somebody would have the ability for parole. But even if it wasn't, he would say, you can still be a positive force behind prison walls, and I want you to promise me to do that. And that's the way he used to end his sentencing. It was unique, but I always thought that it was wonderful in a way.
Well, listen, Aaron Keller, I want to thank you so much for jumping in here at the last minute when we had this breaking news. And I think that your line that you use, crushes the souls of people, is really very apt and right on point. Aaron Keller, that's why he's one of the best in the business. I want to thank him. We're going to take a real quick break, and we'll come back with more of this case and the other trials that we're covering here at the Law and Crime Network.